Well, hello, everybody. I am Laura Grebe. I'm a partner here in Husch Blackwell's Intellectual Property Group. And before we begin, I have this lovely script to read with some housekeeping items and explaining the dashboard if you haven't used this here before. There's some icons on the bottom of your console, and they do a couple of things. First, if you have any questions during the webcast, please submit those through the question box. It'll pop up a little box on my screen to let me know that there's some questions there, and I will do my best to take a look at that periodically and try to answer questions as they come. If for some reason I can't get to them or it's going to require a longer explanation or a more detailed answer than I have time for going through here, I'll reach back out to you and answer by email. If you'd like a PDF of the presentation, that's available in the resources folder. And this program has been approved for continuing legal education hours. To report those hours, click on the CEU icon at the bottom of the screen. A certificate of attendance, including course numbers, will be emailed to you tomorrow, along with a recording of the webcast for watching and sharing. Toward the end of this program, please be sure to complete the short survey. We use the feedback to plan future programs that are applicable to you and your business needs. So that's the end of the scripted housekeeping items. We can get started. I've got 2 cups of coffee here in front of me, one lukewarm and one nice and hot for as I get toward the end of this presentation. So this is going to be a fun one. Again, I'm a partner here at Husch Blackwell in the IP department, and I spend most of my time in patent land, preparing and filing patent applications, both in the US, around the globe. Also deal with some trademark and copyright and contract licensing issues, particularly when it's a benefit to our clients for having that portfolio knowledge. But I do have a rather interesting past life. Prior to joining Husch Blackwell, I did IP work for the government. I wasn't a government employee, but I worked as a contractor, and I contracted with the government to do some of their patent and trademark work. Believe it or not, the government does outsource some of that stuff. So in doing my work, I responded to RFQs and RFPs to support various agencies with their patent and trademark needs. I worked both with defense agencies and non-defense agencies. So if anybody is wondering, yes, I did have to obtain a security clearance, and no, I cannot talk about most of what I did during that time. But I can tell you just some basic, interesting realizations that I made. In talking with my IP savvy counterparts, so generally the IP attorneys that did work for these agencies, there was no problem. We all knew what a patent was. We knew what a patent covered. We knew trademarks. We knew copyrights. We spoke each other's lingo. But then there's contracting officers, and those are the people who administer contracts, enforce the government contracts. They run the audits to make sure that the contractors are performing correctly, and they're the ones that ultimately sign the contracts with me, with the contractors. And those are generally not intellectual property people. Many times they often weren't attorneys. They were government employees who were trained in doing the contracts, and they were trained specifically by their own agency to find contractors to do the work and to meet minimum staffing and demographic requirements and to protect the agency's interest. And those people spoke a completely different language, particularly when talking about intellectual property. The differences were sometimes subtle and not always something that I needed to care about. So oftentimes in my contracts, I'd read, any technical data developed during the performance of this contract belongs to the agency. And honestly, I didn't care. I wasn't developing technical data. I was being hired to write a patent application, and that was, of course, going to belong to the agency. There wasn't any question about that. The inventors were developing the technical data. I was just writing it up. But after 2 years of government contract work, I learned that the way I, as an attorney, spoke and understood IP was very different than how the contracting officers and other non-IP attorney agency people spoke about IP. And the differences can actually be very important when it comes to understanding what contractors as intellectual property developers are doing with the things that are developed under contract. And that brings me to today. The big question is, what is intellectual property? Lots of us will know what it is as defined by the US Code, but there's a completely different set of definitions that apply when you're looking at the federal acquisition regulations, the FARS, and their defense counterpart, logically named the Defense Federal Acquisition Regulations, the DFARS. So let's get going here. Today I'm going to talk quickly about intellectual property under the USC, just to get some basic definitions rolling so that we can compare those properly to what intellectual property is, and more importantly, who owns it when you're contracting with the government and operating under the FARS and the DFARS. And then to top it all off, there's a subset of government contracting that's with the STTR and SBIR programs. Those are small business programs, and they have even further specialized rules governing what IP is and who's going to end up owning any intellectual property developed out of those contracts. All right, I have a poll here that should be showing up for you, and I've been told that I need to stall for about 30 seconds to give everybody time to put these answers in, and then the answers will show up on the next slide. As a presenter, I get a little attendance roster of who has signed up for this and basic job titles, but I'd like to get to know more, a bit about everybody's intellectual property experience. I'd like to know if you spend all your time in IP, is IP your life? Someplace in the middle, are you an IP generator? Or if this was live, would you just be here for the free food? In which case, awesome. Thanks for hanging out. That'll be great. But that'll help me know how quickly or how slowly I'm going to kind of go through these next slides with a general IP overview. So I'll give you a few more seconds here and take a sip of my not scalding hot coffee. And got the right cup. That's good. All right, a few more seconds and I'll flip over to see what everybody's answers were. All right, let's take a look here. All right, so looks like the most here is lots of people working in IP, whether it's directly or more ancillarily as part of contracts. We've got some IP generators. And yay for the people who admit that they would just be here for the food. I wish I could send you food. All right, so I will go I'd go a little quickly through these next slides, but I'll make sure that I get some important points across. When people talk about intellectual property, there's two different things that they can be talking about. First off, intellectual property can refer to creations of the mind that are embodied somewhat in a tangible form. I say somewhat because in most circumstances you have to have some sort of tangibility to those mind creations in order to obtain IP protection. The other thing that people can be referring to when you say intellectual property is the group of legal rights which provide protection for these mind creations. And we're going to be looking at that second one mostly, of course, and we're going to look at the federal statutes that are in place to protect those mind creations. We've got four basic categories of IP that's laid out in the USC. We've got patents, which are, of course, our inventions, trademarks, which are your brand names, your product names, your company names, the origin of products. We've got copyrights, which are basically just any of your artistic expressions, artistic creations, and our trade secrets, which are anything that derives economic value for a company by being kept secret. Very generalized, of course, but we're just getting the point across here so that we can compare to what's going on in the FARS and the DFARS. So this is a particularly important slide. I'm not going to read it to you, but this is the basic definition of patent and what you're getting with patent protection. Patent is for anything that is new and useful. There's particular categories there: processes, machines, manufacturers, compositions of matter. It can encompass a lot of things. It's, of course, not going to encompass laws of physics, mathematical principles, correlations, that sort of thing. Those aren't new. Those are just existing in nature. So this is what the USC 35 USC 101 defines as patent. There's a couple different types of patents. You've got utility patents, and that protects how something is built, how it works, the functional aspects of something. It protects stuff that's typically not it protects things that are not published or available to the public yet, so that haven't been in the public domain, and that's going to be important when we look at some of the information going on when we go over the FARS and the DFARS. And then we've got design patents, which protect the design of the non-functional aspects of an invention. And then we've got plant patents. I've actually never worked with one of those. They protect plants. I've seen them come up a couple times in government contracting, so I list them here just in case. Now, who owns a patent? There's a couple ways that default ownership can work out here. It's most straightforward when you have one inventor and no documents in place. That one inventor is going to be the owner of your patent. When it comes to multiple inventors, the default ownership goes to all inventors equally. That is, each inventor is an equal owner. They're not 50-50 owners. They're not splitting what they're doing with the patent. Each owner, each inventor, whether there's 2 or 5 or 10, each can equally do whatever he or she wants to do with the patent, so long as it doesn't affect the rights of the other co-workers. So that means each equal owner can make, sell, distribute, whatever, license the patent, and they keep the money from their own endeavors without having to split that among the other inventors. And again, that's absent any other writing in place. Equal co-owners cannot assign the whole of a patent or enter into an exclusive license with anybody, because both of those would affect the rights of the other equal owners. This just kind of explains why it's really important in instances of joint inventorship to make sure that you have a background document in place that explains more fully what each of the inventors can and cannot do, or better yet, put a paper in place that assigns the rights of the patent to an entity or to one individual, and you can always license back out. So these agreements in the background change the default ownership from the inventors to somebody or some other entity. In addition to assignment agreements that change default ownership, research agreements and, importantly, government contracts can change the default ownership. And these FARS and the DFARS that we'll talk about later are automatically included in government contracts, and they are going to change your default ownership. Moving on to trademark, real quickly, it's basically anything that can be used to identify the source of a goods. So anything from a word or a picture to a color like Tiffany's blue color, to sounds and scents, those latter being more difficult to obtain but hypothetically possible. Any of those things can be considered a trademark. What I find most fascinating is what can't be a trademark. I'm not going to read it. My absolute favorite one on here, though, is that you can't use the portrait of a dead president while the widow is still alive. I just have, without consent, of course, I have always find that rather interesting and entertaining. It's clear the reasoning behind that, but it's still interesting. All right, who owns a trademark? This is perhaps the more important part of the trademark basics that I want to cover as it comes into play later down the road. Again, generally the user is the default owner. You'd like to think that maybe it's the person who came up with the name, but again, a trademark denotes the source of goods. And if the person who came up with a cool product name isn't selling the goods, they really have no use for it. Agreements, again, can change the default ownership, such as assignment agreements. But again, the entity you're assigning to needs to be the new owner, or they need to be needs to be the new user, or they need to control the user. If another entity, maybe a subsidiary, is using a mark. License agreements, of course, change default ownership in some way, and government contracts, again, they can. Generally, in my experience, ownership isn't the issue when it comes to trademarks and government contracting, but it's more use. That's the issue. Real quickly, what is a copyright? It's basically exactly what everybody thinks it is. It's anything that's been created and then fixed in some sort of tangible form. They've got a nice list laid out in the USC here. Won't read it for you, give you a minute to read it yourself if you'd like. When it comes to ownership, the author is generally the default owner. The USC actually provides for works made for hire, which gives ownership of a copyright to the entity or person who commissioned the work. Assignment agreements, again, can change ownership. And finally, once again, your government contracts. A last overview of general IP is trade secret. Trade secret is generally considered anything that derives economic value from being kept secret, and is the subject of efforts to maintain secrecy. And again, that's a pretty generalized overview, but that's basically it. It can be anything from business methods to pricing to customer lists. The best example for trade secrets would be like a recipe, like the recipe for Coke, or the recipe for WD-40, the recipe for the finger-licking good and spices that KFC uses. Funny story on that. Did you know that at any given time, only 2 KFC executives actually know the recipe for the seasoning? And then there's a third person who knows the combination and location for the vault where the recipe is kept. And these 3 people, they don't necessarily know who each other are, and there's only a handful of people who actually know the identities of these 3 people. And they are not allowed to travel together using the same mode of transportation. So they all can't hop on the same plane or fly the same routes to the same location. They can't have the same car. They can't share cars. They can't Uber together. They have to get to places independently of one another. Just an interesting tidbit on trade secret there. That's how strict that they keep it secret. And maybe a handful of people will remember a bunch of years ago, the secret sauce for McDonald's changed, and people did not like it much at all. And McDonald's actually tried to go back to the original recipe for that sauce. And they actually couldn't because they lost it internally to McDonald's. They ended up having to go back to the manufacturer of it, and they had a legacy copy of the recipe in their records. So if you're going to keep it a secret, but make sure you have a few people like KFC who know where it is. Don't be McDonald's and destroy everything to keep it a secret and then end up losing it. And so that's trade secret here in a nutshell. Who owns a trade secret? There's no straightforward law here, but the general consensus is that the entity that is keeping the secret and benefits from the secret is considered the owner. Again, agreements in the background can change this. And the more important thing to know, particularly when you're working in the government contracting office, is that things stop being a trade secret once the secret is no longer a secret. And you can bet that that's an issue, particularly working with the government when we have FOIA, the Freedom of Information Act, and government agencies talk to one another even when they're not supposed to. So once that secret is leaked, that's what you have. I bet we can all tell here where there's some overlapping protection. I've got an exemplary bottle up there. Different aspects of a bottle can be protected by these different elements. Maybe there's a new material, we got a patent, the shape of it could kind of be trademark, kind of like Pepsi's bottle. Maybe the way you make the bottle's a trade secret. Copyright would be maybe any art on the bottle, or technically a bottle could be a 3D sculpture. So we've got some stuff there. Another way that these protections overlap is also with computer software and that sort of thing. Elements of a computer program can be protected by patent in some cases. Copyright can also protect computer programming. Not so much trademark, I mean the name of a computer program, if you're naming it and selling it by that way. Trade secret maybe a little bit in there. But this was your IP basic overview and who owns what by default under the USC. So just keep this in mind now as we go forward. We're going to switch gears now, and I'll take the next section a little slower because I think this is where the questions are going to lie. We're going to look at how these default ownership arrangements and even the categories of IP change as we step into the government contracting realm. So just to get a quick gauge here, I'd like to know what everyone's experience is with government contracting. Here's another poll for you. I'd like to know if you or the entities you work for have ever worked under a government contract, or if you are right now. If you're maybe interested about it, but haven't quite looked into it enough yet, or there's something there that you're exploring or open to. If you have absolutely no interest at all, you can just say that's not our bag. We're not going to be doing that. That's fine too. If you're with the government, let me know that as well. I don't want to say anything mean. Not that there's anything mean. I thoroughly enjoyed my time contracting with the government, but I'd like to know that as well. I didn't think I saw anybody on the attendance roster that was with the government, but just in case. And I'll give you a few more seconds here while I take another sip from my not scalding hot coffee cup. It is about halfway gone, so I'll have to switch to my scalding hot coffee cup and hope that it's cooled down by now. All right, let's take a look at what the answers were on this slide. All right, so we have lots of people here who have worked under government contracts or they currently are. Next most popular answer is that's not really our thing. It's awesome that you're here though, just in case you run into others that do work with government contracting so we can all speak the same language. Handful interested. We've got, okay, some people with the government. Excellent. Awesome. All right, so now we're gonna switch gears completely here. We discussed patents, trademark, copyright, and trade secret under the USC. And now we're gonna switch over and take a look at some categories of IP that are laid out in the FARS and the DFARS. And this is to keep in mind that IP ownership rights can change based on agreements in place, and government contracts do just that. They are an agreement that's in place, and they change certain IP rights. And in government contracting land, there's three main categories of IP that are different from the U.S. federal code that I'd like to go over. And those are patentable technology, technical data and computer software, and copyrightable materials. So you'll notice right away that these are a little different than what the US code sets forth, and there's some things that are missing. That's not to say that trademarks are not recognized. It's just rather that they're usually not at issue, or that the government contracts refer to trademarks in the same way that the USC does. Same with trade secret, although generally as a rule, I don't consider anything that you do with the government to be a secret. It's going to get talked about in some way or another. I'm going to look at patentable technology first. The first thing that you'll notice on this slide is that there is actually a reference back to the US code. Despite that, the FARS and the DFARS refer to patentable technology, not patented technology or the rights granted by a patent, but something that could be patented. So it's a little bit broader than patent as defined under the USC. And the FARS and the DFARS generally are on consensus on this and use basically the same language. So just to show you again, we've got the patentable technology when you're contracting with the government, and then you've got your patents, which is a smaller little portion of that. So when you're working with patentable technology, keep in mind that it's something bigger than patent. Next, some definitions here for technical data and computer software. These next two slides are going to be word heavy, but I want to make sure that the exact language is in front of you. You can go ahead and read that while I talk. I'm not going to read it to you. We're just going to start quick with the definition of data, which is essentially recorded information, and it's inclusive of technical data and computer software. Technical data then is a subset of data, and it's recorded information of a technical nature, nothing like using the word that you're trying to define in the definition. Importantly, computer software is excluded from technical data. That is because computer software gets its very own definition. Computer software is the computer programs that have the instructions and the rules that a computer follows, and the recorded information with the source code. Importantly, computer software does not include the databases or the computer software documentation, so like the user manuals and that sort of thing. The computer software is just the code and the recorded information, like the source code and the designs and the formulas and that sort of thing. Copyrightable material, a quick definition here. There's not really a good definition. Copyrighted works is another phrase that is used with copyrightable material. And you see copyrightable material and copyrighted works come up a lot when referring to material made prior to entering a government contract. So those instruction manuals would fall in there that were made before contracting with the government, or if you've made art, or if you're entering a contract to do perhaps an agency history or like an informational brochure of some sort, any art that you created that was done before that contract is where you'd see it used, or referring to copyrightable material made during performance of a contract. 9 times out of 10, you're likely going to know that your contract is for the creation of a copyrightable material, such as when you're making a video for an agency or that sort of thing. It doesn't come up quite as often in the more typical supply agreements and things with the government, but copyrightable materials, again, going to be, actually, it's probably about the same as copyrighted, since copyright rights vest on once a work is fixed in tangible form. So it's probably about the same, pretty close. Here's just another quick basic overlapping circle graphic that I made. It's a little boring to look at. I'm not very good with colors, but I just wanted a quick and easy way to visualize the difference and overlap of some of the definitions of IP when we're looking at the USC versus the FARS and DFARS. I repeated that patentable technology, patent, overlapping circle, but then we've got technical data and computer software. And like I mentioned before, some aspects of computer software can be protected by patents. We've got some overlap there. It might be a little bit smaller than what I made it look like in that diagram. And I could not find a good way to get copyright on there as well, but technical data and computer software can both also be protected by copyright, so that would overlap there as well. Probably a little bit more of an overlap than with patents. So there's the basic definitions that we've got. Oh, nope, here I've got some copyrightable and technical data computer software up here. I lied. That was the next slide. I blinked. So there's that, just pretty basic. So when you think about it, the FARS and the DFARS could have very easily stuck with the USC categories and definitions and made it really easy on IP people and IP generators to work with the same language, but they did not. And the question there is, why did they not do that? And the answer is because of ownership and use rights. The government wants to have a piece of the cake when they're doing these contracts with the contractors. And by providing these special definitions and carving out these technologies separate from generally patents and copyrightable material, they can more easily spell out what it is they'd like to own or have rights to. So now we're going to shift and take a look at what I call rights allocation. That includes ownership, yes, but it's also going to include any default use rights that are provided to the government under the FARS and the DFARS, things like compulsory licenses and that sort of thing, or anything that the government can do that generally a third party would not be able to do with somebody's IP. And we're going to look about the rights allocation for these different contracting classifications in intellectual property. For patentable technology, I've got a little reminder up there what we're talking about when it comes to patentable technology. Generally, the contractor retains ownership of patentable technology that's developed under a contract. And in certain instances, the government may get a default license. And this is different than default ownership under the USC. And when contracting with a government, the contractor is agreeing to these changes by signing that contract. So now I'm going to go into a little bit more detail on some of the less generally changes to default ownership and rights allocation. In some instances, the government can get government use rights. So if the technology was first conceived of or reduced to practice in the performance of a contract, the government gets a license, the use rights, the right to use the invention without significant restriction. And these situations are usually when federal funding was used, at least in part, to develop the technology. And in some instances, the government may get ownership or require the contractor to license the technology to third parties. So this is march-in rights. And these are usually instances where a contractor doesn't protect the subject technology enough, or they do an act or omission that forfeits their rights under the contract terms, or if a contractor cannot fulfill the contract, they may be required to license to another third party that's going to come in and save the day, essentially. That other contractor is going to have to use the IP that was developed to do the solution in some instances. So you heard me mention that a contractor may have to do certain things in order to keep ownership of technology. In most contracts in which IP is being developed, a contractor is going to need to, first of all, disclose what has been developed. And they have to disclose upcoming potential disclosures, so uses, sales, publications, that sort of thing. And depending on your contract, there's going to be other specific rules that go with that in terms of timing, when you have to disclose something that's been developed under a contract to your agency, and whether you have to file a patent application will be in there. In some instances, the contractor will just have to give written notice to the government that they intend to keep title. So it's very important to read the contract and know what those are so that a contractor is not giving up rights that they could otherwise have. And failure to do these things will result in the government being able to come in and take the rights from a contractor. So how does the government get title? The contractor can, of course, decide not to keep ownership of some IP, some patentable technology that's been developed. Again, if the contractor fails to act, they don't take one of the steps set out in their contract. The government can also decide to pursue patent rights in patentable technology that was developed in countries where the contractor does not want to pursue it. So working with a US-based contractor, if the contractor is really only interested in obtaining patent protection in the US, whether that's because of market or financial constraints happen sometimes as well, the government can step in and decide they want to obtain patent protection or pursue patent protection in Europe or Asia. If a contractor files a patent application on patentable technology and for whatever reason decides to drop a patent prosecution, whether that's a final rejection that they can't overcome or they can't overcome in a way that gives them enough freedom to market a product in the US, or even if it's just for finances, it's not worth it to them for their portfolio, to a contractor for their portfolio, the government can step in and opt to take over patent prosecution as well. Limited situations require assignment to a government. This is a short list up here. The actual situations are a bit more nuanced than this, but basically think of it in terms of national security. If there's a technology that the government is paying to be developed, and the US would not want a foreign government to have that same information, those are the situations in which the FARS will require an automatic assignment to the government. I personally have not come across those, but they do exist. Just real quickly, some other government march-in rights. A contractor may be required to license to the government or permit a government to sublicense in limited situations. These are relatively rare. People will know what's happening. The FARS do allow for it, and this is generally when the government has safety concerns about a current contractor but still needs the job complete. So you might be asking yourself, what happens to the contractor? We've got all these scary provisions that say the government can take ownership of IP developed under a contract, that the government can own this patentable technology. What happens when that does happen? The contractor is not necessarily SOL. The contractor did put in the time and effort to develop this stuff, and they do get something. The contractor will get a revocable, non-exclusive, royalty-free license to practice. Generally, there's rights to sublicense. There are going to be limits on transferability, and it depends on the particular FARS or DFARS that are in your contract. Because this is a CLE presentation, I think I have to put in some practical steps for people to do when you're contracting with the government. So those of you who are contracting with the government or have in the past or looking for it going forward, Here's some practical steps for you so we can meet our CLE requirements here. What can you do to protect yourself as a contractor with the government and make sure that you can get the most ownership of your patentable technology as possible? The first one is pretty clear. Just make sure you read your contract. There's going to be lots and lots of numbers and language in the back of that thing. You want to make sure you know what version of the game you're playing and make sure you follow those rules. Don't try to press your luck and come in a day late on disclosing something. If anything, be early if you can. To the extent possible, try to use existing solutions in coming up with your deliverable to the government. If you can use something off the shelf as opposed to developing yourself, that is always best. And also make sure you document everything. Make sure you know what was done and when. That's particularly important when it comes to timelines for disclosing to the government. If you can show that it was that a particular patentable technology subject matter was developed on such and such a day, then you're for sure going to know by what date you need to let the government know certain things. You also want to make sure you document your disclosure dates as they'll affect potential patent filing dates. So just make sure you keep track of all of that. Moving on to technical data and computer software. This slide is just a repeat summary of some of the definitions. Recall, technical data is basically recorded technical information. Computer software is your programs. Computer software is not the user manuals. Again, computer software documentation is your user manuals. The databases are the collections of information. So generally speaking, when you've got technical data and computer software, and I'm lumping them together because the rights allocations generally mirror one another for these two. Generally speaking, the contractor is going to retain ownership again, and this is generally consistent with the USC, but there are situations in which the government gets a license. And the particular scope of the government's license for technical data and computer software is going to depend on whether the technical data or computer software is commercial or non-commercial. And it's also going to depend on how it was funded, whether there was private funding, federal funding, or some sort of combination of both. So here's where it can get pretty tricky. What is a commercial item? So commercial items are those that are developed outside of a government contract, preferably before a government contract, but there's something that was developed separately from your performance under a contract. It's a software solution that's provided from off the shelf. Logically speaking, for commercial items, the contractor owns that, assuming it is the contractor's product. The government isn't going to get any retroactive rights in that, no. The government will get a license, though, if these commercial items are used in a solution for the government. And that just kind of flows and makes logical sense. So here's where it gets more complicated, though. For non-commercial items, or those items that are produced or developed, and they use produced or developed depending on whether we're talking about technical data or computer software. So for those products either produced or developed during the contract, the rights allocation depends on the type of funding. And that's why it's really important to keep track of where money comes from, when things were developed, and by whom. And there are 3 different levels of rights allocations or scopes of rights that the government can get depending on the type of funding. With 100% federal funding, the government gets unlimited rights. And I'll go over what specifically each of these are in a moment. So then we've got the other end of the spectrum. We had 100% federal funding, the government gets unlimited rights. With 100% private funding, the government gets limited rights or restricted rights. Again, the phrase changes depending on whether we're talking technical data or computer software, but the government gets some form of limited or restricted rights when the technical data or computer software is developed with private funding. In the middle, we've got technology that was developed with a mix of funding, some federal and some private. And in those instances, the government gets government purpose rights. So what are these? Unlimited rights. That's for things developed with 100% government funding. Essentially, the government can do anything that a person could do with it. The contractor gets to do ownership, and the government can do anything, like an equal co-owner of a patent as discussed earlier. The only thing that the government could not do is assign the entirety of the IP or enter into an exclusive license, because that would affect the contractor's rights. Same with the contractor. The contractor can't do something with that technical data or computer software that would limit the government. If the data or software is non-commercial and developed with 100% private funding, so jumping to the other end, the government gets limited rights. The government can use the technical data or computer software, but they cannot license or disclose to third parties outside of the government. Importantly, if you as the contractor think your data or software is non-commercial and developed with private funding, it's really important to mark that material with limited or restricted rights, depending on which one applies. This puts the government on notice, very similar to a copyright marking. If the data or software is non-commercial and developed with mixed funding now, the government gets government purpose rights. The government can use it without restriction, just like in the unlimited rights. And the government can authorize others to use the data or software, but only for government purposes. The government does not get totally unlimited rights equal to the contractor. So while there's not a full-on assignment here, there are laws in place which alter the ability of the default IP owners, as would otherwise be determined by the USC, to act. And that's a huge deal, particularly when you consider that the FARS and the DFARS carved out this computer software and this technical data as something completely different. The government particularly calls these groups of IP out to get these particular scopes of rights. One big important thing, particularly with technical data and computer software, is to be aware of alternative clauses. There's some clauses in the FARS and the DFARS that contracting officers can kind of slip into your contract. I say slip in, good contracting officers I found will point out if you've got some alternative clauses. Some of them, it's just standard for their agency to use these alternative clauses, so you might not always be flagged. So there's one particular alternative clause that gives unlimited rights to the government in data that's delivered or produced in performance of a contract. And the contractor's use then is limited to performance of the contract. And that can be a problem if you're not ready for it. There's also some reachback clauses. When you're operating under a government contract, you generally have a deliverable of some sort that you need to provide to the government, and that deliverable will be defined. But you're also going to be generating information in the background that goes to support that deliverable or to develop that deliverable. And those background bits of information, that background data or that background computer software, might not be spelled out as required in the deliverable. Reachback clauses will allow the government to go back and say, hey, any of the stuff that you developed behind the scenes that went into this deliverable, by the way, we get that too. So that's important to look if you have any reachback clauses in there. I've also found that agencies sometimes have their own set of specific clauses that they can put in there that affect what needs to be delivered or what type of rights the agency is required to get. So it's a very good idea to just read through those and make sure that you understand very specifically what the government and the agency in particular is asking for. All right, again, some practical takeaways to meet all the requirements here. It should be pretty clear by now. Make sure you're reading your contract. Try to use commercial products, try to use commercial technical data and computer software in your solutions. Otherwise, make sure that you have it identified as something, as commercial. Document and label everything, and try to use private funding when you can. There's going to be instances where, of course, you're going to need to use the federal funding. That's the point of entering into these government contracts. But make sure you try to keep that federal funding separate from the private funding so that you can make a clear delineation between what was developed with what. Basically, all of this boils down to make it easy for the government to understand what you as the contractor are intending to own, what you're developing separately, and make it hard for the contractor to reach further than what is allowed. And you do that by documenting. All right, copyrightable material. This is the last bucket of IP that I'm going to go over when it comes to the FARS and the DFARS. You'll notice that I've been already cutting some of the slides short as we go. I see we've only got 15 minutes left. Copyrightable material, it's typically, there's two instances when we see copyrightable material in government contracts, and that's, again, with the technical data and computer software, or if you're being contracted to create a very specific work for the government. So if you're being commissioned to do a piece of art or a sculpture or a photo collage or a historic writing, a history of an agency or something along those lines. In that later case, you'll know what particularly is involved because you're being hired to make the copyrighted works. Otherwise, it's going to be any ancillary copyright rights that are with the technical data and computer software. So generally, the contractor is going to get rights in what it is that's done under performance of the contract, but may need to get consent, particularly when you're writing articles during the performance of a contract that you intend to publish if there's research going on and you want to release some of that research. Less generally, to keep rights, again, the contractor must put the government on notice that you're claiming rights, and you do that with the copyright notice. So it's the little C with the date and your entity name. The government will, of course, have some rights in copyrightable material that a contractor is owning, but those are generally limited to reproduction rights, distribution rights, and then performance and display rights. And not all of those rights are going to be applicable to all works, depending on what we're talking about. Like software, for example, the government will get a right to distribute, to reproduce. Performance of that would be a little bit more interesting. It would be fun to see them do a live dance interpretation of software or something. But the government generally gets some restricted rights in copyrightable material. Less generally, some more particular situations, contracts may include something called special works clauses. And that's, to make a comparison, that's pretty close to a work made for hire. So the special works clauses are in contracts for the government commissioning somebody to do a particular work. So like, again, histories of agencies, investigative reports. And in those situations, the government can get unlimited rights. Those clauses act essentially as the work made for hire clause permitted under the USC for copyrights. So what about material that's not first produced under the contract? The contractor is prohibited, first of all, from incorporating that data unless they mark it as such. But in doing so, the contractor is also giving the government permission. They're giving the government a license to use that work because they've included it in the material supplied under the contract. And the scope of that will vary. The scope of the government's rights can vary there depending on what FARS or DFARS are in place. There's also some FARS and DFAR provisions that say that the rights can be negotiated separately. So there's a chance to work on that there too. Last practical takeaway, practical steps for a contractor keeping title to the most that they can when it comes to copyrightable material. Again, read your contract and keep good records. That's basically the gist of it. The whole thing, all the practical takeaways for maximizing contractor ownership of IP developed under a government contract. Read your contract, know what it is. Once you know what it is, you can take steps to develop technology outside of that, around that, or at the very least, you know the rules of the game that you need to go through to keep the ownership. All right, to conclude, I just want to make some comments on some special government contracting arrangements. Those are the STTR and SBIR programs. The STTR is the Small Business Technology Transfer Program, and SBIR is the Small Business Innovation Research Program. These programs are both geared for small businesses and nonprofits to encourage their innovation and commercialization of new products. The FAR and DFAR provisions I just went through are applicable to government contracts in general, but the SBIR and STTR programs also have some of their own rules, particularly when it comes to IP ownership. So there are just a few differences that I want to highlight that are applicable to these two programs specifically. One of that is when it comes to technical data. If you can't tell, technical data and computer software appear to be of particular importance to the government. My background is biochemistry, so while I find that particularly important, I don't know what's so intense to the government about computery stuff, but they particularly really like it. But when you're operating under an STTR and SBIR award, technical data, which is funded by the award, so technical data that's developed with the funding that comes with the STTR and SBIR award, that technical data gets a little extra protection. The government cannot disclose that technical data outside of the government for 4 to 5 years, depending on what the rules are and how the contract's written. And that protection can be renewed in a sense, as in subsequent awards, that protection rolls over to include new data. So when you're doing an STTR, SBIR award, those come in phases. There's phase 1, phase 2, and phase 3. And phase 1, you develop technical data and it's protected. And then in phase 2, if you develop more technical data or further data, that 4 to 5 year period is applicable to that new data as well, which can include some elements of the old data. So the protection continues to roll over as you go down the STTR and SBIR paths. So when it comes to the STTR and SBIR arrangements, usually we have the small business entity partnering with either a larger entity or a research institution. And up until now, I've referred to the contractor as the default owner. And I want to be clear now, talking with the STTR and SBIR programs, that there's really more than one contractor, because you have the small business in a partnership arrangement with either a larger entity or a research corporation. And how those two entities, or if there's more than that, how those 3 or more entities split IP is a different story, and that needs to be negotiated separately. So when I'm talking here about ownership in technical data, I'm saying contractor, but it's really going to be whoever is the owner there that's agreed to behind the scenes. Just to be clear there. So the STTR and SBI rights for technical data are not negotiable. So if the government doesn't know that the contractor is claiming something as technical data, any disclosure before marking that is just tough luck. You have to do it, you have to mark it. Another quick note is, I mentioned before that these two programs have 3 phases. You can think of it as phase 1 is like R&D proof of concept. Phase 2 would be your production and refinement, and phase 3 is really intended for commercialization. So contracts that are awarded for phase 3 don't necessarily look like STTR and SBIR research contracts, because the emphasis is no longer on that research, but the commercialization. And the data protection, though, still applies. It's just that the problem with phase 3, it's harder to show that the technology or the data is linked to the funding. It's easy to do when the award is for R&D, but when the award is for commercialization, you have to take extra steps as a contractor to make sure that the data developed clearly ties back to what was done in phase 1 and phase 2. There's another thing to note is that pre-existing data is not protected under this. So if you're coming into these STTR and SBIR programs and you've done some initial groundwork, which you should have, this initial groundwork, that initial data is not protected under the STTR and SBIR programs. All right, patentable technology under the STTR and SBIR programs. When it comes to the contractor's own IP, the same considerations as brought up before apply, but there's some additional burden that will be placed on the contractor. An example of that is subject invention is frequently used in the SBIR and STTR contracts, and this is a subset of patentable technology. Nothing like creating 50 definitions to work from. It makes it all very confusing. The subject invention is logically the technology that's going to be the point of the SBIR or STTR contract. So we've got our patentable technology is the big circle. We've got patents under the US code a little smaller, and now we've got subject invention, and that's specific to the SBIR or STTR contract. We previously discussed under the FARS and DFARS the activities a contractor must do to retain title of patentable technology, such as disclosure within a limit, etc. The same activities must be undertaken for subject inventions, but the timelines are significantly stricter. Generally, under these programs, a contractor must disclose the subject invention within 2 months of discovery. But then they have 2 years to make a decision on whether or not to retain ownership. So we might ask, why this gap? This gap is there to provide additional time for the contractor to do the refinement and development that's necessary under these STTR and SBIR programs. In addition, and just like the requirements under the FARS and DFARS, the contractor, and again, contractor could be any one of the entities involved in the relationship here. The contractor must apply for a patent and continue to pursue it. If the contractor drops a patent application or elects not to file, the government can pick it up. All right, last slide here. Some other considerations quickly when it comes to IP under the STTR and SBIR programs. Frequently in these programs, the entity developing the technology might want to use an element of third-party IP, whether that's some sort of off-the-shelf product or a solution developed by somebody outside of the arrangement, or even some IP developed by the larger entity that the small business is partnering with, or with the research institution. Do you need to, as a contractor, you should consider whether you need to use it, and who's going to own that in the end. You have the licenses that are necessary. Is what you're developing going to be an improvement on that existing technology? So it's very important to consider that ahead of time and make sure that you have the licenses and the assignments in place, or the agreements to have them in place ready to go. The last point I want to make is the issue of agency pushback in phase 3, which I discussed that quickly before. It's really difficult in phase 3 awards under these two programs to show that technical data developed in phase 3 properly ties back to the R&D of phase 1 and 2. So keeping good records there is very important. And with that, I think I'm done. I will sit here. I don't see, I think I see one question here. Let me take a look at it here. All right, so I've got one question that came through here. If you modify a software, would the government gain access to pre-existing source code? So if the pre-existing source code was pre-existing, developed outside of a contract, developed with private funding, completely separate from anything, and then you're going to use that and modify it for the government to use, assuming you go through the proper steps, you will own it, yet you will own that improvement, yes, but the government will get some ability to use, they'll get that license in there to use the stuff and maybe disclose to other agencies, depending on how that goes, if you're going to use that as the solution. So the best thing to do is, if you want to avoid the government having any access to the pre-existing, would be to develop a completely new solution and use that only for the contract. But otherwise, just make sure you go through the right steps of being able to maintain ownership then if you're improving that. All right, I'll keep my eye on that box while I read the rest of my script. They gave me two scripts here, one for opening and one for closing. So we'll move on to the closing script here, and we should finish right on time. So first of all, thank everybody for joining me today. I hope this was at least entertaining, hopefully a little bit helpful for you or your organization as well. As a reminder, This program was approved for CLE hours. To report your hours, make sure you click on that CEU icon at the bottom of the screen. You'll get an email with your certificate of attendance and a recording of this webcast to watch later if you want to, and to share with your colleagues. Also, be sure to complete our short survey. We'd love your feedback to plan future programs, and we want to make sure that those are applicable to you and your business needs. And that is all. That concludes our webinar. If you have any other questions, feel free to email me. Thanks.